Go ahead. What page are you on, counsel?
I'm sorry, Your Honor. This is page 14, Mr. Blandino.
Okay, we're going forward with sentencing today. So if you substitute in today, we're going forward.
I'm sorry, Your Honor. Joseph Gerson, 13876. I'm here from as appointed counsel.
Oh, for appeal?
Yes.
Oh, okay.
That's
Okay, all right. So I'm gonna continue. I know it's on for sentencing, and so I'm gonna trail it. I know you have speakers as well.
I believe that we're not going to have the speakers today. They're just going to submit on the letter that was provided. So, but I'm fine. Whatever you're on, I'm fine hanging out, Your Honor.
We can go forward. I thought that you would have speakers. Is he here? I'm assuming he's here.
Yes, he is here.
I agree. Okay, the record reflect that Mr. Blandino is present. He's here in the courtroom, and this is on for sentencing. Mr. Blandino, do you know of any legal cause or reason why judgment should not be pronounced against you at this time?
Yes, I know of many reasons. There's a motion to disqualify held against you in the writ that's parallel. Well, let me enter my appearance. Kim Blandino. Anyway, that I filed a motion to disqualify based on new information, and it's very serious stuff. As you know, there have been investigating.
You're represented by counsel, so
Yeah.
anything that you would have filed is a fugitive
There's
document.
motions for new trial as well that's pending.
Fugitive document. Fugitive
But
document.
as far as I know, there's a
You're not
placeholder there.
permitted
Yeah,
to
you're-
file you're not permitted to file any pleadings because you are represented by counsel.
That does not mean, Judge, that an attorney, if you force counsel on me, either here, now, what you're doing, or with Mr. Gerstmann, who's a purported appellate counsel, or post-verdict counsel, or post-trial counsel, that he might not adopt and ask to amend that motion for new trial, because as you know, under the law,
Okay.
it must be filed
All
within
right.
7 days.
So Mr.
You
Bateman,
cannot
is
move
there
forward with
anything that
sentencing.
you want to
No, wait,
raise?
Debbie, hold on.
If I may, Judge.
Devin
There's just a
Hartsock,
few
if I may.
housekeeping matters. No. There are just a few housekeeping matters I did speak to the
Thank you.
prosecutor before, just regarding the PSI. I would note, Mr. Blandino had asked me to seek the new PSI be issued, but I don't think that's necessary. I think we can clean those up. There's just a couple of, the main issue, Judge, was the credit for time served that was listed in the PSI is unfortunately the mistake that goes against Mr. Blandino. They had 200-something days, I believe it was. Yeah, we have it calculated as 134 days credit for time served.
That's correct, Your Honor.
Okay.
Additionally, I believe, I don't know what page it is, they listed Ms. Pendergraft, the man for whom Mr. Blandino is the caretaker, as his mother. She's obviously not his mother. And the ages of his children are wrong. I believe they're off by a year. They have each.
Okay.
Maybe younger. And then, yes, he did, I believe this one, it's splitting hairs, but I will bring this up to Mr. Blandino, that they listed Mr. Marwood. So I believe it's here in the court today. Listed him as an FBI agent, and I know that he is a city marshal. He did testify that he's deputized and on an FBI task force, so calling him an FBI agent is splitting hairs in my opinion, but at least bring that
Okay,
issue.
say that again,
It's not FAA agent. it's
I can clarify, Your Honor, specifically as to page 5 of the PSI, paragraph 6 down. It indicates that on April 29, 2019, the officer with the Federal Bureau of Investigation, later identified as victim 2. So in that portion, it's identifying the detectives that were involved in this investigation as officers of the Federal Bureau of Investigation, which in fact they were. They were both task force officers with the Federal Bureau of Investigation.
That's not
with the Joint Terrorism
I
Task Force.
object.
And so that's actually very accurate. It doesn't say they're special agents of the FBI, it says they're officers. They were task force officers.
So yes, I'm not being splitting hairs, but I believe those are the other matters. So if we could have the record of the minutes reflect those corrections that should be made to the PSI.
Absolutely. So by virtue of the jury verdict returned in this matter, I hereby adjudicate you guilty of count 1, extortion, and count 2, impersonation of an officer. Does the state wish to be heard?
We do, Your Honor.
Go ahead.
Your Honor, we come before you today asking for the defendant to be incarcerated. Right off the bat, that's what I'm going to tell you we're looking for here. I think that the number one thing that sticks out is the defendant's conduct throughout the crimes that he committed in this case, throughout this case, and throughout his history. The defendant is somebody who has zero respect for the law. He's somebody that only believes that the law is here to serve him as he sees fit. Just as he sees the religion and the word of God that he interprets in the Bible is here to serve him as he sees fit. That's something that I think comes to mind when I look at his sentencing memorandum. There was a retired judge who had wrote a letter in his sentencing memorandum. And, I essentially, two of the things that I noticed weren't in that particular letter that came to mind of my pre-trialing of that individual before trial, as they were noticed by the defendant as a potential witness, was that that individual had indicated that the defendant's religion was whatever he wanted it to be, essentially. And further indicated that in talking with the defendant over all these years and seeing his interest in the law, the question had come up, well, why did you become a lawyer, Mr. Blandino? Well, the response that was reiterated to me by Kim Blandino was, well, then I would have to follow all the rules, and I don't want to do that. That's exactly the case. Is Mr. Blandino thinks that he can go around doing whatever he wants, coming into these courts and petitioning inappropriately, making inappropriate appearances, making inappropriate filings, and making inappropriate contact with judges, and he thinks he can do it because he doesn't have to follow the rules. Further, you look at the sentencing memorandum, I believe there's at least 3 letters in here which tend to support the defendant's unauthorized practice of law, helping other individuals left and right, him indicating to these individuals that he can help them, and all 3 of them indicating, yes, I go to Mr. Blandino for legal advice and assistance. That is something that Mr. Blandino has
Please
done.
don't interrupt.
I need a chair and they won't let me sit down. I have a bad leg and I need to sit down.
He can sit down.
Can we sit down?
Sure.
Thank you.
Have a seat.
Thank you very much.
You bet.
Here in this particular case, Your Honor, the defendant repeatedly contacted Michael Federico, pro tem judge for the city of Las Vegas, in an attempt to influence his actions in his capacity as a pro tem judge. In doing so, he caused Mr. Federico and his family immense fear, to the point where Mr. Federico has since moved out of this jurisdiction. You heard from him at trial. As a result of what was going on, he was carrying a firearm around him. Him and his wife were worried about the path that their children had to take to school. Extremely concerning, and even more so, the fact that the defendant was given opportunity after opportunity to withdraw. He did not have to go down this path. He pressed forward every time that things seemed to take a lull in his mind. And what he did is he ended up upping the ante and ultimately continuing to threaten Mr. Federico and adding threats to what he was indicating he would do, where he ultimately did make good on some of those threats, which was sending the partners of his firm a package full of everything, all the disparaging comments, everything that he had thus far been sending to Mr. Federico himself. All for what? All because he wanted to have control. He wanted to have control over Mr. Federico, Judge Pro Tem Federico in that capacity, and he wanted to influence the justice system, as we see that he does day after day when he appears in front of this court. It's, as of a couple days ago, he's filed this fugitive document. And this has to be, what, the 23rd motion to disqualify? Something that he is doing for the specific purpose of inappropriately influencing the justice system, inappropriately influencing these proceedings, seeking to delay. Just as he walked in here today, seeking to delay this sentencing hearing, it makes clear why he's filed that new, approximately 23rd fugitive document motion to disqualify. These are actions by the defendant that are not going to stop. These are things that are just part of who he is. And we take a look at the theories of punishment. In an American system of justice, we're dealing with really four primary theories of punishment. That being retribution, deterrence, incapacitation, and rehabilitation. Well, what becomes clear is that rehabilitation is the predominant focus for the American justice system at this point in time, given the state that we are in our current history. Rehabilitation is not an option for Mr. Blandino. We take a look back. Mr. Blandino has prior felony conviction from 1994, violation of custody rights, something he was convicted for in a bench trial. And there too are so many similarities from 1994, his acts in 1993 and before, to what he is doing now, today, decades later. And I would just reference this for the court for a bit of background, is that the United States Bankruptcy Court out of the District of Nevada had issued an opinion in 2004, a published decision by the Bankruptcy Court. This was a published decision. It's in re Bradshaw. This is Michael and Nancy Bradshaw, who had filed for bankruptcy. Nancy Bradshaw is Defendant Blandino's former common law wife, the mother of his children. She had been placed in dire circumstances as a result of the defendant's actions, and was seeking to have bankruptcy. Mr. Blandino entered that as a creditor, and ultimately the federal judge issued a scathing published opinion talking about Mr. Blandino and his history. And I think that the history that is recounted by the federal court is so similar to what we're seeing today that I have to mention it. And just for the background, the court there indicated that Nancy Bradshaw as the plaintiff, Kim Blandino, were married, in quotes, in 1987. They had two sons, Zach and Andrew, born in 1988 and 1999. And then in 1991, they separated. That's when Nancy had petitioned the state court and was granted primary fiscal custody of both of the children. Although there was an order in effect that was not introduced into evidence, there was no dispute that the boys have legally resided and remained with Nancy since that date. From the time they separated in 1991 until June 6, 1992, Kim and Nancy worked out a periodic visitation schedule. However, June 6, 1992, Kim, without explanation or warning, abducted and kidnapped both boys. Although Kim changed his identity, he was cited in Portland and eventually apprehended with the children in Phoenix, Arizona, on or about January 25, 1993. In all, the disappearance lasted 7.5 months. The children's trauma had been exacerbated by Kim telling them that their mother was dead and that she had spiritual cancer. During that time period, Nancy had no communication with her boys whatsoever. After Mr. Blandino was ultimately convicted and sent to prison, he served a 6-year prison sentence. He gets out of prison. It was at that time that there's a domestic relations court appointed family therapist to start reintroducing him to his kids again. That therapist, after conducting numerous meetings in the process of reunification, indicated in her report to the court that Mr. Blandino conducts his life by his interpretations of the law of man and God without regard to the expectations of society in which he lives, ultimately leading to issues. And further, no surprise that Nancy was seeking to move out of the jurisdiction. The defendant at that time took further action. I think that is consistent with the behavior that we've seen here. That's when he then filed a lis pendens on their property. 3 days before Nancy's home was to sell, it collapsed. The home sale collapsed because of the lis pendens that he filed. Something that
A lis pendens on our house.
on her home, yeah, and it was totally without merit.
Is that a question to me?
No, it's
Okay.
not.
At trial, Mr. Blandino stated that the lis pendens was to stop the sale because the family court was not fast enough. He'd indicated here further that to another psychologist that was introduced into the case as far as reunification,
So he
that
admitted to filing the Liz pendants in bad faith?
he did. He admitted to the court at trial that it was for the purpose of stopping the sale because the family court was not fast enough. That's a quote from the federal judge quoting Mr. Blandino. And then further, he indicated to Dr. Gary Lenkite, who was also appointed by the court, that he referred to the kidnapping of his children as, quote, seeking self-help. Seeking self-help, Your Honor. That's what the defendant's been doing. He's been doing for decades. Inappropriate, illegal self-help. That's what he did in this case. And frankly, it's become clear that he just has no respect for the law. And so that's why I stand here today and tell you that there is no way to rehabilitate Mr. Blandino. Probation is something that is never going to be adequate for Mr. Blandino. It's never going to send a message to him, and all he's going to do is continue with his self-help and continuing to obstruct the process. So what would we even be looking at if we were looking at probation? We'd be looking at a system now that has been changed recently by the Nevada legislature that leads us to a point where Mr. Blandino could get no more than 36 months on probation. And further, the Division of Parole and Probation would be required to submit to this court a discharge at 18 months, halfway through. 18 months of probation. That's just inappropriate. The punishments that have been considered and changed by the Nevada legislature just don't work for probation in a case like this. And as a result, we take a look at the other theories. I think that retribution is a theory of punishment, essentially that the punishment must fit the crime. Here in this case, a prison sentence is a punishment that would fit the crime. The prison sentence that I'm going to ask for is a punishment that would fit the crime. And then we further go to deterrence. And under the deterrence theory of punishment, there's two separate theories, right? General deterrence and specific deterrence. The general deterrence theory of punishment being that the punishment that is handed down to Mr. Blandino will deter others from the same criminal actions and the obstructions of our justice system here in Clark County, Nevada. That's something that I think weighs heavily on the fact that there's many people who have watched this trial, who know about this case. I mean, we even have a letter in the defendant's sentencing memorandum from someone who's a fan of Mr. Blandino. The last page, one of his fans. This is a sentence that will generally deter other people from doing the same thing, the same illegal conduct that Mr. Blandino's been doing. And then we look to specific deterrence. That's all we can hope for at this point in time for Mr. Blandino and anything that is going to change in his life is that prison and the fear of future prison is something that generally deters and specifically deters his bad and criminal behavior. I think that that is probably the most clear theory of punishment that needs to be met in this case. What also becomes clear is that the fear of being incarcerated is something that is real to Mr. Blandino. It's something that does affect his behavior. As we've seen every single time he was looking at potentially being remanded from house arrest, what did he do? He filed frivolous motion to disqualify after motion to disqualify, trying to interrupt these proceedings inappropriately so. What did he do? Right before this sentencing hearing, where he knew the state of Nevada is going to be coming in here and asking for him to be incarcerated, he files another frivolous motion to disqualify. This is something that I think we take into account here as we go forward and we craft a sentence for Mr. Blandino. And what I'm asking for is a sentence that will do just that. Number one, we have the 134 days credit for time served. What I'm asking for is first, as to count two, the maximum punishment of 364 days in the Clark County Detention Center. And then as to count one, I'm asking for a consecutive sentence of 1 year minimum to 10 years maximum. The effect of this sentence will be that the defendant will essentially serve maybe 18 months, maybe 12 months before he comes before the parole board. At that point in time, it's going to be incumbent upon the defendant, his counsel at the time, anybody who's coming to speak for him, whether he has other fans that are coming in at that time, to show the parole board that he is somebody that should be released in the community. But the number one thing that this punishment does is it gives him the maximum amount of punishment on the back end of his sentence. 10 years of punishment hanging over his head. Something that will give him a longer term of supervision than probation ever could. Something that will give him more worry about going to prison and more concern about having to correct his behavior in the future and ensure that he's not introducing himself in a criminal manner into our criminal justice system or into our justice system as a whole during that time period. So that is why I believe that that is the most appropriate sentence here in this case for Mr. Blandino. Again, probation is just simply not an option to adequately punish Mr. Blandino. It doesn't serve any of the prominent theories of punishment in this case, that being, number one, deterrence, both specific and general, as well as retribution. And so with that, Your Honor, I'm going to ask you to impose that time. I also would mention that the defendant had previously brought up that he was going to seek to have credit for time served or apply for every day that he's been on house arrest. That's just something that is not supported by the law under NRS 176.055, as well as the case of State v. Jackson from 2005. House arrest is just simply not counted toward credit for time served. I would further mention that the Nevada legislature, shortly after they had changed the probation structure, which makes probation inappropriate for the defendant in this case, they had also sought to include house arrest in the credit for time served calculation in AB 160, which did not pass. So with that, Your Honor, I ask you to sentence the defendant as to count 2, 364 days, as to count 1, a consecutive 12 to 120 months.
Anything further?
No, Your Honor.
Okay, Mr. Blandino, do you want to say anything prior to sentencing?
Am I going to get to speak?
Would you like to say anything?
Yes, I have lots
prior
to say, Judge.
sentencing?
Can I counter what Mr. Dickerson
We-
was doing?
That's your opportunity.
I'm allowed to do that? I've got a lot to say. You know, I think I'm just going to run through his points because they're so fresh in your mind, and then get to what I was going to say before I heard such lies from Mr. Dickerson. And they were lies. These things are unfounded, he said, and they were based on hearsay. He brings up an R.V. Bradshaw. No, my religion is not whatever I want it to be. You know, the Lord is my shepherd, I shall not want. The scriptures are very clear on that. We're supposed to eliminate personal and selfish wants. This quote that he said, why I couldn't become a lawyer, is because if I did the bar and I really tried to represent my clients as much as possible, I'd probably be suspended or disbarred.
That's correct, you
Or-
probably would.
I would be
You
because,
conducted yourself the same way.
no, because I would fight zealously and vigorously, and this, Ben Bateman, was a great standby counsel, but he's afraid of you, he's afraid of the district attorney, and you cannot operate out of fear. And I cannot operate out of fear except fear of God. Now, given the opportunity to move forward, as Mr. Dickerson said, this is not true in that I had valid reasons for filing every motion to disqualify, and it doesn't matter, it's 23. There was multiple motions to disqualify that I had to file before I finally got a judge from another district to hear the case. So you can't calculate those in, because I was successful in getting another judge, albeit just to hear the motion to disqualify Judge Wilson. That's in the record. This isn't fantasy. This isn't some federal court judge that is making things up. And he did make some things up there. The Judge Wilson could have been, Judge Bell easily could have said, no, Judge Wilson, you're going to get this case in chief, rather than just a motion to disqualify. So it took repeated motions to disqualify just to get that. Then you have to start anew. You can't put it as one continuous continuum as though they're all equal. This latest motion to disqualify is on good grounds, and there's good current events happening. You've got your address on somebody else's house sitting up there, and Justice Kavanaugh is threatened to be assassinated. He's a Supreme Court justice because of the impending Roe versus Wade case. The person's living in that house, and you had a death threat against you by a defendant. You testified in the case because some maniacal defendant threatened your life, and you testified. That's a matter of public record. So you are a person that, now in the Judge Salas case, that I put in the motion to disqualify, that's where a U.S. District Court judge, his son was killed because they got the public records of that judge, and now they're sponsoring federal legislation to eliminate those. But you, when refusing to get these monies collected by the treasurer, you put somebody else's life in jeopardy. And that's callous and careless disregard of somebody else's safety. All you have to do is go down to the treasurer and claim that money, and then the address gets taken off the website. The sending package to the firm, I got a note there. Anyway, or for primary rehabilitation is not an option. By his own relation of the events, the conviction that happened on the violation of custody rights, there hadn't been any kind of penalty incident or anything in all these years, 20 years, and you properly, in the trial, forbid Mr. Dickerson, because you know it would be more prejudicial than probative, to introduce that old conviction to the jury. But now he knows he can bring it up here and try to inflame your passions as somebody who has been threatened by a defendant. Attempted murder, I believe, conviction was garnered in that case, but I'm not sure of that. But the rehabilitation, I've worn this ankle bracelet now on and off for over 3 years. It's been since May, well, I've been incarcerated May 21, got out on the 29th. So on and off since May 29th. This latest thing that you did graciously, I have to admit to that, gave me bail pending this sentencing. You put me on high level, moved me up from the mid-level. But I have a curfew, and I didn't violate any of that. No, there's been no house arrest review. So for him to say there has been no rehabilitation as he jumps from 1994 in some flux DeLorean capacitor device and jumps forward as though there hasn't been life that has lived between then and now, and good behavior on my part on the house arrest. You'll remember the ankle bracelet was taken off so that I could go visit my PhD son. Both of those boys are a blessing to me, Zachary and Andrew, both in their own way. Low maintenance kids, no drugs, no smoking, no any of that junk. And I can tell you, which the record will not reflect, and it can't, if I wouldn't have taken those kids or not returned them from a visit. I was given them on a visit by Nancy voluntarily. I didn't bring them back. True enough, I did pre-plan that because of the danger those kids are in. Those kids would have been dead. It was only that life-saving measure. And the other thing he doesn't bring up, which he could find the information, surely. I was offered a plea bargain in that case. I could have taken a misdemeanor plea bargain, credit for time served of 1 day. 1 day I spent on that charge when I was brought back, voluntarily brought myself back to the state. And I turned that down because the statute was bad. And I felt I owed it to other individuals that had subsequently been prosecuted. To my knowledge, I'm the only one that ever got a felony on that charge because I took it to trial. It was vindictively put in because I took it to trial rather than give me the misdemeanor drop, was what the legislature intended when they moved that charge from misdemeanor up to a felony in 1980 so that the FBI would extradite from another state. They said, well, in the interest of justice. And sure enough, that legislation was changed. The statute as it was then is not as it is now. And I pointed that out to him. As a matter of fact, during the time I was in prison, when the legislature modified
If you want
it.
to talk about something that
Yeah.
applies to this case, I'd love to hear it.
I did not ever tell the kids their mom was spiritually dead or had spiritual cancer. I told other people that later. Never would tell the kids that. As a matter of fact, they didn't even miss their mother. during that time, the 8 months that I had him. Exclusive custody. As a matter of fact, that's the other thing too. I went to a licensed attorney, Bob Luke, that signed that letter, was a practicing attorney before I took exclusive custody of the kids. I asked him directly. He's a licensed attorney, worked with John Fadgen. He's a former family court judge now. I asked him, is it a crime if I take exclusive custody? My kids are in grave danger. He said, well, as long as there's no court order, that is not a crime. Now, it may be bad legal advice, but I followed it. I wanted to know whether it was a crime or not. And he said that it wasn't. And so this probation, I've already had 3.5 years worth of probation on this ankle bracelet. I've appeared for every court appearance. You have disputes on that?
What do you think is appropriate?
Huh?
What do you think is appropriate?
Well, obviously, a new trial. I filed a motion in that regard. Ben did not, he didn't.
What do you think would be an appropriate sentence?
You mean if I had no choice otherwise than you sentence?
What do you think would be an appropriate sentence?
I'm asking you a condition on that, Judge. I don't think any sentence is appropriate. I think,
Okay, so
if you-
he doesn't want to answer my questions.
Wait a minute.
Go ahead.
how do you, ask that question again with all the
What
qualifiers?
do you think is an appropriate sentence?
I don't think I committed a crime, Judge.
Okay.
I was trying to resolve a legal dispute. I took the very discipline that you had and Winker had against you with the Commission on Judicial Discipline, and for those 2 days, I used that as a template to go to Mr. Federico, because he asked me over the phone, and I told him, if I don't get an apology, there's no sense in me preparing a document. I was preparing a
Okay, so
pre-filing.
anything else regarding sentencing? Because I've heard all the facts and I've heard all the witnesses.
But here's the thing, Judge. You really should have disqualified yourself. I asked for it to be done
Anything
non-pro
else?
tunc. No, you want to cut me short again, and I have a lot to say
Because
here.
you keep talking about stuff that we've already resolved, and we're not gonna redo it. We're not gonna
It
rehash.
has not been resolved. How
So
in the
is there
world?
anything further?
Look,
If not, I'm gonna have Mr. Bateman speak.
look. You should not have been removed in 2015 by the Commission on Judicial
Okay.
Discipline. What you did to Rita Dotson was so wrong, you knew it was wrong, and then
Okay,
you
so
lied to the
here's
Commission
this
on
now.
Judicial Discipline.
He doesn't want to speak anymore.
I'm sorry,
so
this
Mr.
is part of it.
Bateman,
No,
sit down.
I have the right to speak under common
You're
law.
done.
I have the right to speak
You're
under
done.
common law,
You're
Judge.
You're done. Mr. Bateman,
Have a
do
seat.
you wanna say anything?
Yes, please, Your Honor.
Sit down, Blandino.
Okay, can I ask one more
Sit
thing?
down.
If you had to take
Mr.
a sentence,
Blandino, sit
I should be
down.
given no more than probation.
Have a
Does
seat.
that answer your question?
That does.
This woman here, I take care of her. Michael,
I understand, I know
I
that.
need to take care of her.
I know that.
I will do all the
I've
public
seen her
service I
here
did.
today, I know that.
Yeah, I've got the medical studies that Ben's doing. I got a 5-year study that could help a lot of people. I'll donate the money to charity. I do not want the
So
money.
you do have the ability to talk about sentencing when directed to.
Okay,
Okay.
can I talk about it then?
Mr. Bateman,
Can I
go
talk
ahead.
about it then?
Mr. Bateman, now I want
Can
to
I
hear from
elaborate
you.
on that?
Thank you, Your Honor.
I want to hear from Mr. Bateman.
Yes. Thank you, Judge. As for sentencing, you've heard from the state, you've heard from the defendant, and I don't know if we're going to hear from Mr. Federico, he was noticed, but, and I think what's appropriate here, I think to bear in mind, is one of the admonishments I gave the jurors is to, I think it's still apropos today, is to sort of separate our personal feelings about Mr. Blandino and not let them cloud sort of the, our ability to see objective reality. I mean, everyone that's been involved in this case has suffered indignities, personal insults from Mr. Blandino being a part of this case. And so it's, I think, appropriate to step back and sort of dispassionately look at what we have here. And I think one of the points that Mr. Blandino made that I think is valid here today is that there's a significant passage of time that the issues that the state brought up of his prior case in 1994 is really not relevant to what we have here today. There's been a significant passage of time with him not doing anything, saying that he has no respect for the law. And if that were true, he'd have a long string of arrests, convictions, and other run-ins with the law. He's been on the electronic monitoring program, Judge, yes, off and on, for 3 years without any incidents. He can submit and obey authority. He can. He's shown that. I think additionally, he hasn't been to Mr. Federico's house. He hasn't been to his office since April 25th, 2019, the last time he dropped off a letter. I know Mr. Federico testified that he thought he saw him and other things, and I understand. Maybe it affected him, but his subjective beliefs aren't, like I said, we need to look at the objective reality. Mr. Blandino never was on an ankle monitor, never went anywhere near Mr. Federico or his family or anyone or anything, or anyone in his family or anything of that in that nature. He hasn't violated the stay away order also from who was it on Judge Nordstrom. He hasn't gone and done anything of that matter. And in fact, if you recall during the testimony of the trial, detectives went to his house. They searched his house pursuant to the search warrant, and they didn't find anything that was threatening at all, nothing that would raise a red flag. And that's because he's not a physical threat to anyone. He is not. And so I don't think it's appropriate to send someone of his age to prison based on that, because he's not really a physical threat. And he's, let's be, and I think anything that the state brought up, I think certainly can be cured with conditions of probation. Judge, he has, and I think it's right what Mr. Dickerson said, that the threat of going to prison or incarceration motivates him. That's why he didn't violate his house arrest. That's why he was perfectly compliant, because he knows what the consequence of that would be. I think that same similar belief will be in effect if Your Honor should grant him probation. And I think that, okay. And to say that, to say that he has zero respect for the law is not proper. What he cited were examples from more than 2 decades ago, almost 30 years ago. But what's more recent is that he hasn't had any incidents on house arrest, no contact, and I think the things are overblown. The threat, I think we're giving him maybe too much credit. On all the legal filings can be cured really by any condition of probation. Additionally, we have counsel who will be representing him on the appellate matters. And quite frankly, I mean, it's ironic, the Supreme Court denied the one filing he made, citing Blandino v. State, his prior conviction in a twist of irony. So I think if you make it a condition of probation that any fugitive documents filed while on his pursuing his appeal would be considered a violation of his probation. He'll have counsel who is very experienced and very capable of handling that. And so any abusive process, quite frankly, can be curtailed, can be cured with conditions of probation. Additionally, yes, he does care for Ms. Pendergraft. I think that is perhaps one of the redeeming qualities he has that I think helps keep him grounded, that keeps him centered, that keeps him focused. And I know he does a lot. He does a lot of work on her behalf, and he did that. He knew the family prior to her when she was with her. I believe they were neighbors. Knew her family, knew her husband, and when he passed away, and then her son passed away. He made a promise that he would take care of her, and he has, and he's done that, I believe, for the last 13 years or so. Okay. So I'm sorry, he didn't informs me he didn't know her husband before he passed away. But he didn't know her son was, they were neighbors, and made the vow that when her son passed away, that he would take care of her, and he's done that. And I think that's another reason why probation would be appropriate, because again, that fear of incarceration, he knows the effect of incarceration would have on Ms. Pendergraft. I don't think he would risk it, quite frankly. I think, you know, not to insult him, I don't think he's a threat or someone who we should see as a threat. I think it's a little bit more someone deserving of pity, quite frankly. His, and all of these filings that he's done, the two things he's gotten were letters of caution issued to Judge Baird and Judge Herndon. You have to understand the Nevada Commission on Judicial Discipline to even understand their process and their machinations to really even understand the letters. And we heard, because no one else had ever given him the time of day. No one, on all his previous filings, he's doing this for years, at that time when he was staying out of trouble, everyone ignored him, and he went away. There was nothing. We're here because, yeah, Mr. Federico did something, and
What did Mr. Federico do?
pardon? Because Mr. Federico contacted the police and started that ball rolling in front of me. And to say that, and, you know, I mean, the state ran that, oh, they contacted Mr. Federico, but Mr. Federico asked for that. You know, when he called him and said, what do you want? What are you proposing? Give it to me in writing. Okay? Send him something, okay, give me something else. So, you know, I don't know that it's entirely genuine for the state to say, oh, well, he kept harassing Mr. Federico, sending him things that they were being asked for, and sort of laying that trap. Again, these things are, like I say, it's almost more deserving of pity. The letter to the partner, you want to read it. It was, you know, again, that's what's open. It was woefully unprofessional. I honestly, I don't know that Mr. Federico's job, and I can't say that, but I would speculate, Judge, that the partners knew that this was not someone to be taken seriously. I don't believe that his job was seriously in jeopardy. Someone of his reputation and renown here in the legal community with his partners and having this letter, I don't think was something that, again, was taken seriously. I think we give him too much credit for his, I don't know, ability to cause havoc. I think he is deserving of probation, Judge. I think someone of his age, of his temperament, would be a target in prison and is not, you know, and is not appropriate. I mean, I think, look, the law is what the law is. The state legislature passed these new laws as to probation, and you know, we ought to respect the law. That's the thing that came from this trial, and so I think, despite what they are, you know, they are what they are, and I think again, the fear of incarceration for Mr. Blandino is real. I think that he should be given probation. I don't necessarily disagree with a longer sentence on the back end, so that he would expire on parole and, you know, I guess have a long time to expire on parole if you're going to use that appropriate. But I think you'll see, Judge, that if given probation with the threat of going to prison at his age, I think he'll comply. He'll be compliant. I think the concerns about filing or doing other things, I think that's really the main, I guess, threat, as it were, would be filing things that are not germane. He has been deemed a vexatious litigant, so in that regard, that's cured, as it were. He has to get permission, I'm not exactly sure how it works, permission from the chief judge, I believe, in order to file. And so I think, and then
He
anything on
didn't
his.
do that with these last filings.
Pardon?
He didn't do that with these
I
last.
understand,
There's about
and-
3 different things that were.
And I understand, and I think that's why I suggested making it a condition of his probation that anything that's not on his appeal, since he's represented by counsel, that any fugitive documents that are filed would be considered a violation of his probation. I think that can be, would cure that concern. That obviously wasn't, I don't know, there was discussed at his release. So I think, Judge, he, obviously, he doesn't feel that he did anything wrong, I understand that. And, but I think that probation is appropriate while he seeks his appeal. He will be represented by counsel, and so I think it is appropriate to grant him probation. I think the long term at the end, so that he doesn't, to fix the law for him to expire, is appropriate, and I would submit on that.
In accordance with the law of the state of Nevada, this court does now sentence you as follows. In addition to the administrative assessment, the DNA fee, and the collection fee, you'll be required to submit to genetic marker testing. As to count 1, the court's going to sentence you to 12 to 120 months. Count 2, 364 days in the Clark County Detention Center, concurrent to count 1. It'll be suspended. You'll be placed on probation not to exceed 3 years with the following special conditions. You'll be subject to intensive supervision pursuant to NRS 176A.440 as deemed appropriate by parole and probation. You're to have no contact with the victims in this matter, either directly or indirectly. You are not to file any documents unless they're consistent with the vexation litigant order. You're not to file any fugitive documents. So when you're represented by counsel, you're not permitted to file documents on your own. Your attorney is required to file those documents. So you'll be required to follow all court orders, undergo a mental health evaluation, and any counseling as deemed appropriate. And you'll be required to comply with all general conditions of parole and probation. Were there any other conditions that the state was concerned about?
We have concerns. In looking at the current conditions, the no contact with victims directly or indirectly. The defendant has been already trying to indirectly contact Mr. Federico as he has filed a pro per civil suit against Mr. Federico in the federal court for
what?
for going to the police in this case, essentially.
That was filed in July
And
of this last year.
again, something that's totally inappropriate, and he's been using Mr. Federico's counsel to try to talk to Mr. Federico, to relay messages, relaying to him some proposed offers of settlements and whatnot. Again, it's just another action by Mr. Blandino that's totally inappropriate. So I don't know how the court wants to handle that.
He's to have no contact with Mr. Federico at all. I mean, obviously, if they're in other litigation, he can have contact with his attorney only. He's not to have any contact with Mr. Federico. Anything else?
Further, we would ask that the term be fixed for 3 years. Because I just think that we're in a position right now where he's going to be up for discharge in 18 months. It's just going to be inadequate for any type of supervision over him. Further, we would
I
ask.
think a fixed term would be appropriate. I can set it for a fixed term. I believe they will still submit.
Yes.
And so I'll make that determination at that time.
In addition to that, we would ask for a full financial disclosure of the defendant. I think that what has been called into question as far as his finances is his current living situation. He's relied heavily upon his caretaking of Ms. Pendergraft here in this case throughout to avoid any sort of incarceration or a prison sentence. The state does have concerns about that situation overall. He's indicated that he's being paid $500 a month by Ms. Pendergraft for his caretaking services, but obviously that's disclosed there. We just ask for a continuing financial disclosure in this case.
Okay. To his probation officer?
Please.
Okay. And that you make full financial disclosures to your probation officer as deemed appropriate.
And then does I just want to make sure whether the general conditions have it or not, but I think it should be specifically stated as a full electronic search clause.
Oh, sure. Yeah, that's
I'm
part of
sorry, I
the,
missed that part, full
yeah,
electronic
it's
what?
one of the general conditions of parole and probation is that you'll be subject to search. your person, where you live, your electronics.
And further, as with the conditions that have already been placed on Mr. Blandino as far as filing with the courts, we would ask that we continue with the same restrictions, time and place restrictions for Mr. Blandino for the courthouse. This courthouse, as well as the municipal court, that he not be permitted to enter these facilities unless he actually has a case on calendar.
And that's appropriate. Court's gonna order that you not have any contact with the courts or go in the courts or the courtroom unless you're there on official business.
I can call
for
them up on the
yourself.
phone though, right?
No, unless you have official business.
No, that's what I'm saying, if I call up to initiate a case,
If you have
or to
official
get documents,
business,
or to get certified documents,
that would be official business.
okay?
So if you have
Well-
official business that's outside a case your attorney is representing you on,
I got one of
But you
those
wouldn't be able
remands
to do
because
it on
Khalil
this
Wiggins
case.
said official business,
Okay.
Judge, and
all right, so he
it
is
was in
not,
dispute.
you know what, if I were you, if you have a question, I'd ask your lawyer, because if you come back here on a revocation hearing, it's not gonna be good for you.
And with that same, as far as his official business comments, another concern that's raised throughout his history in this courthouse, as well as within his sentencing memorandum, is that if he seems to view and other people view him as having official business in their legal proceedings, we would like that the court make it very clear.
That would be illegal, because he's not a lawyer, he cannot represent other people that would be practicing law.
But I
without
can
a
file as an
license.
intervener in the case.
And him seeking any sort of investigation or contacting courts on behalf of anybody else be absolutely prohibited.
That would be correct, because that would not be on his behalf. So, at this time, I know you want to appeal it, and the Supreme Court has indicated that you would not be able to represent yourself on appeal. So
The
at
appeal's
this
already
time,
pending, Judge, it's, the
Okay.
briefing's just been
okay,
suspended.
they're not gonna let you represent yourself,
84433.
okay? Just so you know.
We'll see.
So, good luck, because they're not gonna let you represent yourself. But if they do,
That doesn't mean they
Have
won't
at
let me file supplemental briefs as in
Okay.
Domenico versus
all
State.
right, then that's up to them,
I
and
see.
that's why
And
they're
then
the
they say,
Supreme
these
Court.
aren't fugitive
So,
documents.
Mr.
Sorry,
Bateman,
we are concluded then with
We
the
are.
sentencing and the conditions, then I would move to withdraw at this time.
okay, so Mr. Bateman can withdraw at this point, and the notice of appeal has been filed, correct?
Yes, 84433 is the case number.
Okay,
Mr.
I just wanted to
Blandino.
make sure,
Well, he does have appellate counsel, I believe, will,
Purported appellate counsel. Yeah.
through Mr. Christensen's office, I believe, will be handling all the matters of the appeal.
And so
including the
counsel will be
notice.
appointed now, I would just make sure you check to make sure that notice of appeal has been filed and that it's all good, and then the bond will be exonerated, he'll be released from house arrest, and you're to report to parole and probation within 24 hours of leaving court today.
And just to be clear, new counsel is appointed in this case as well. For all
That's
future
correct.
cases. Thank you.
And I need to issue an objection to that. I want to represent myself on appeal.
I know, that's what I thought I tried to make clear.
I had to make an
The
objection.
Supreme
to
Court's
that.
not gonna let you.
Yeah,
However, if they decide,
we'll see.
then that's
I
great.
just talked to them last month,
That is
and I told them they
fantastic.
can't do that.
I do not believe if you represent yourself, but if they decide otherwise, that's
They can
fine.
in every other appeal
So
but
that's
criminal
why I
appeal.
just wanna make sure your appellate rights are protected
Uh-huh.
unless and until they make that decision.
All right, so are you confirming counsel today, Joe
I am
Thurston?
appointing counsel today.
Okay, over my objection then.
Over your objection.
Yes.
Thank you.
And so the motion
we're
to.
done. Go ahead and pick up.
All right,
Thank you.
Thank you.
Thanks, Judge.
thank you.
I hope you're safe.
Excuse me?
I said, I hope you're safe at all times.
Grab your things and exit the courtroom before you self-trouble.
Thank you.
Counsel?